I ask unanimous consent the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table.
Is there an objection? Without objection.
Mr. President, I rise today to talk about two separate issues that seem to be confusing in our current climate at this point. The first of those is something called nationwide injunctions. Now, for folks that don't track this issue of nationwide injunctions, they have no idea what this means. I would tell you it is a fairly recent thing. We have three branches of government. Any civics student in middle school knows that. We have the legislative branch, we have the executive branch, and we have the judicial branch, and all three have unique roles. The legislative branch that we're in right now, we write the law. The executive branch executes the law. Judicial branch interprets the law. Now, we know there's a difference between the House and the Senate. The Senate has a responsibility and the House has a responsibility, and they're different, but they're both in the legislative branch. Judicial branch also has different pieces as well, just like the legislative branch. There's a Supreme Court. We know that. It's right across the street. There's 9 justices that sit there, and they're the final decision maker on what the law says. But there's also daughter courts. There's circuit courts below the Supreme Court, and below the Supreme Court, there's district courts. District courts are scattered all over the country. And those individual small district courts that are scattered all around the country, those individual courts, they make a decision on the person that's in front of them. Now, again, this is fairly simple civics. When you have a federal case in front of you, you go to the district court and you file and you get time in front of a judge. Now, it may take time to be able to get there, but they make a decision on what is in front of them. That's what district courts do. They don't make decisions on something that's in a different state. The fine judges that are in Oklahoma make decisions about the case that's in front of them in Oklahoma. They don't decide a case in Indiana because they're not in Indiana. And it's not a case filed in front of them. It's only the case filed in front of them in Oklahoma. Now, if there's a dispute about that, it can be appealed, and it goes up to a circuit court, and it takes in a region, and if there's a dispute even there, they take it on to the Supreme Court. Pretty simple, until the last several decades. You see, prior to 1960, there was no such thing as a nationwide injunction. No one even considered that. But we started seeing this beginning point where a district judge in a court in a single state would hear a case and to say, this is so big, I'm not going to let this go to the circuit court or to the Supreme Court. I'm going to, in my lowest court in the federal structure, I'm going to decide for the entire country, not just the person in front of me. And there were just a few that happened at that time, and the Supreme Court kind of looked away because they seemed like big cases. But then it started to rise. During George W. Bush administration, there were 6 nationwide injunctions that were done in these local district courts. Under President Obama, there were 12 nationwide injunctions that were issued. Then under President Trump, the first term, there were 64 nationwide injunctions. As more and more individual district courts decided, I have an opinion, and I'm not going to decide about the case in front of me, I'm going to decide about the entire country. Under President Biden, there were 14 nationwide injunctions that happened. In fact, President Biden's Solicitor General, the one who actually argues to the Supreme Court, warned that nationwide injunctions halt the legal government actions and policies. See, this is not a Republican-Democrat thing. This is a constitutional thing. This is the United States constitutional structure to say what is the role of lower courts, what is the role of a circuit court, and what is the role of the Supreme Court. We as people in our nation, we honor the constitutional construct. And for me, it's exceptionally important that the courts are blind to these issues and that they take action on the case in front of them and not a case that's not in front of them. Senator Grassley has introduced a bill to rein in the use of nationwide injunctions. His legislation is called the Judicial Relief Clarification Act. It makes it very simple. It is an important case. is an important piece of legislation to decide how we're going to handle cases like this. It is very simple. Courts decide the cases in front of them. That has been the practice up until the early 1960s. We need to get it to be back to the practice again. Not a Republican issue, not a Democrat issue, a constitutional issue. Nationwide injunctions are a backdoor way for judges to actually write legislation and to bring the decision of the executive branch to a halt. The executive branch does have checks and balances, as does the legislative branch, as does the judicial branch. Those checks and balances are clear. If the executive branch does something inconsistent with the Constitution, it goes to our federal courts and quickly works its way up through the district court, circuit court, to the Supreme Court. The Supreme Court is the one who checks the executive branch, not each district court around the country. It is the Supreme Court. And we need to be able to get back to that process in the days ahead. That needs to be done. So I'm looking forward to seeing Senator Grassley's piece of legislation actually move. A second issue. This body for the last week has had a conversation about CRAs, and most of Americans would just flip the dial and go, I don't even know what that is. Well, the Congressional Review Act is a CRA. It's actually only existed in the last several decades as Congress found a reason to do oversight of the executive branch, especially when the executive branch writes what's called a midnight regulation. Now, that doesn't mean they wrote it at midnight. That means they wrote it and put it in place at the very end of a presidency. A Congressional Review Act says if there's a piece of regulation that's put in place, a rule that's done by an agency, and it's put in place, especially when there's a change in Congress and the White House, that the next Congress and the next White House can look at it and say, yeah, that's out of bounds. That's too big. That needs to be stopped. It was actually first used under President Bill Clinton. He put in what's called an ergonomics rule that literally changed the rules for every keyboard, every desk in America that would be produced. It was a giant rule they did at the very end. The next Congress came in and said that would cost hundreds of millions of dollars. And by the way, why should we in the federal government care what everyone's desk is like? Let people choose on that. And that simple statement, that simple first time that it was actually used, has started a process now of saying if an administration at the last minute puts in a rule that Congress then comes in and says you overreached your bounds, we can check it. Now, how do you determine whether it's a rule or not? What's a rule, what's not a rule? Because a lot of times agencies put out guidance or they put out orders, they put out all kinds of things. The Congressional Review Act is very specific. It says you can only take action on this when it is actually a rule. Well, there's two different ways that that's determined, actually. One is how much is it going to cost the entire economy? If it's over $100 million that it's going to cost the economy, it's a rule. It's going to have a massive effect across the entire economy. The second way is pretty straightforward. The Government Accountability Office, you'll hear it often referred to as GAO, in 2018, they came out and wrote their legal decision and said it can either be a big thing that costs $100 million across the government, or I'm going to quote GAO in this in their decision that the CRA, the Congressional Review Act, gives agencies the primary responsibility for determining which agency actions meet the CRA's definition of rule. In other words, agencies get the first option to say, is this a rule or is this not a rule? If an agency says it's a rule, it's a rule. That's what GAO said. They came back a couple of years later and rewrote an updated document. GAO came out again and said in their legal opinion, when an agency submits a document to our office, that is GAO, to our office under the CRA, we consider that to be the agency's determination that the document is a rule under the Congressional Review Act. Now again, everyone's glazing over on this because this just seems like legalese. Why are we even talking about this? Well, because it's been in the news this week. Because something unique happened. In 2022, the state of California put in a request to the Biden administration and said, we want to do a rule that's different in our state for electric vehicles than the rest of the country. Now, you may say, well, they can't do that. Well, actually, interestingly enough, California can. California is the only state in America because they had environmental rules even before the Clean Air Act was done. And so California got a waiver, basically, to say if your rules are at least as strong as the Clean Air Act, you can have your own rules, but you have to ask permission. So that's part of the law that was originally written on the Clean Air Act. So California approached the Biden administration in 2022 and said, we'd like to have an even stronger rule on emissions and on vehicles. We want to have a rule that says by 2026, 35% of all vehicles have to be zero emission, or that is electric vehicles, by 2026. Now, they asked for this in 2022. So they said within 4 years, we want 35% of all the vehicles sold in California to be zero emission. And by 2035, we want 100% of all vehicles to be electric vehicles, to be zero emission vehicles. Now, they asked for that in 2022, as I mentioned before. The Biden administration took a look at it, and in 2023, the Biden administration sat down with the GAO, Government Accountability Office, and they started working on the text for this. And the specific question was, how could we make sure that this is not a rule, this is an order? And for months, they worked to be able to shape the language, to be able to make sure it was an order, not a rule. And then the Biden administration sat on it and did nothing with it. In the meantime, 11 other states said, if California does that for electric vehicles, we're going to do that as well. Because here's the other thing about the law I didn't mention. The way the Clean Air Act gave permission to California to be able to do their own rules, the Clean Air Act is also written to say, if other states want to adopt the California rule, because it's at least as strong as the national, other states could do it. So in the next few months from 2022 and 2023, 11 other states adopt this rule. Suddenly, this is not a single state issue. This is a national issue. In fact, it would now affect 40% of all the vehicles sold in America. This just shifted. This is not about one state anymore. This is almost half the vehicles sold in America now are going to have a new set of rules. Biden administration sat on that request. They didn't move on it. Now, they'd gotten their opinion worked out with GAO in 2023, but they didn't move on it, quite frankly, because the American people hate mandates. We don't like them at all. We like choice. We like to make our own decisions. I would dare say everybody in this room uses a different kind of ink pen because we all like our choices and options. We drive different cars. We wear different colors of ties and different shoes because we like our options. The Biden administration knew most American people would hate this rule because it suddenly created a nationwide mandate for what kind of car you could buy, and it had to be electric. So they sat on it. After the election was over, in late December of 2024 and into January of 2025, the Biden administration dropped their quote-unquote order and gave California permission now to be able to do zero-emission vehicles. By 2026, next year, 35% of vehicles that have to be sold across 12 different states were going to have to be zero emission, which would dramatically change car sales in America. They did it after the election. That is the very definition of a midnight regulation. That is the very definition of a rule. It meets both criteria. It's well over $100 million of impact onto our nation, and it affects multiple states. So when the Trump administration came into office, the Environmental Protection Agency immediately re-upped this, and they laid down and said, that's definitely a rule. That's a rule. The agency declared it. Now it's definitely hit both definitions. The agency declared it's a rule, and it's over $100 million of impact. But then a letter went to GAO. Remember I said in 2023 they had worked with the Biden administration? Someone in this body wrote a letter to GAO and said, hey, that thing you worked out with the Biden administration, do you still have that in a file? And GAO sent a letter back and said, well, we declared this in 2023 just an order because it only affected one state, just California. Here's the problem. GAO, as I mentioned at the beginning, in their very own legal opinion, said if an agency says it's a rule, and GAO doesn't even get involved. Literally, GAO broke its own legal opinion to now declare it's an order. Why would they do that? Well, they would do that to prevent this Congress from speaking to that rule. It would no longer be under the Congressional Review Act. I told you this was technical, but this was a fascinating little plot that went from 2022 all the way to the present to try to figure out how to get an electric vehicle mandate in America without ever having a vote in Congress. It was slick. It was well-shaped, except it was dependent on one thing: GAO breaking its own legal opinion. I happened to call the leadership of GAO just last week and said, as far as you know, has GAO ever declared something not a rule when the agency said it was a rule? And after a moment of silence, he responded, as far as I know, GAO has always deferred to the agencies until now. They literally broke their own policy. They literally violated their own legal counsel. So now we're in a quandary. GAO has broken their own legal counsel. We have an issue that will have well over $100 million worth of effect onto the country. Is now a near nationwide mandate on electric vehicle sales across the country without ever having a vote in Congress. And our Democratic colleague says, you can't change it because we worked a way to be able to fix it so you couldn't. That's not true. This body worked extensively with the Parliamentarian's Office. This body worked extensively across the aisle to be able to have conversation, talking with members of the Democratic caucus to say, do you really want to have in your state a mandate that's sitting there? We don't. Not only that, what will this do to our economy across the country? This was not about challenging the essence of the Senate. This was not about breaking the filibuster rule. This was not about going nuclear. This was about confronting an entity that broke its own rules intentionally to prevent this body from acting. This was a decision to make to say, can an agency impose on America a mandate that Congress never spoke to? Never. Or does Congress get to speak to this? I would say to you as a member of the United States Senate, the United States Congress is the lawmaking body for the country. The United States Constitution begins with all legislative power shall reside in a Congress, not in an agency that wants to have electric vehicle mandates for every American. That's not how it works. So we worked to make sure that we were clarifying one simple thing. In the Congressional Review Act, in this time, as it has been every time it's been done, and for every time in the future, this one simple question: when an agency says it's a rule, is it a rule? It has been every other time until this time. We clarified that one question. It didn't change the dates of the Congressional Review Act. It didn't change the process. It answered one question that apparently was in dispute, that was never in dispute before, but now appeared to be in dispute. When an agency says it's a rule, is it a rule? And we clarified what it's always been. The answer is yes. It's a rule. And then we acted on that. And this body said, no, we will not have a nationwide mandate for electric vehicles across the country. By the way, I don't have any opposition to electric vehicles. If somebody wants to buy an electric vehicle, they should be able to buy that. I think a lot of them look like great vehicles. Buy it if you choose to. But we're Americans. This body should not mandate that everyone has to be able to buy one. This body should make the path that if people choose to buy one, they can. That's setting the rules of the road, saying, here's the definition of a safe vehicle. Pick any one of those safe vehicles you want to be able to have. But we just set the rules of the road and then get out of the way and let people decide which vehicle they want to drive on that road. That's what has happened this week. Now, I understand there's been a lot of bluster and a lot of trying to redefine what actually just occurred. But what has occurred this week is choice for the American people and clarification of what has always been. When an agency says it's a rule, it's a rule. Just like it was last year, just like it is now, just like it will be next year. Technical, but important, because the American people want to follow the United States Constitution and know that all legislative powers reside in this body, not in some other building somewhere down the street. With that, I yield the floor.